And we have a dedicated series of dedicated websites, social media communication, and a number of other outlets. Today, we are going to be dealing with the really important topic. This is a topic that I know garners a lot of attention around the world. Class actions and its various iterations, which every country has its own version. The US certainly has a well-known one, but it's been a developing phenomenon around the world. We're delighted to have my law partner today, Grant DAVIS-DENNY from Munger, my law firm, who will be speaking about the US situation, and my good friend, Marc Jones from the Stewarts firm in the UK. Marc and I have been working together on US-UK issues in a variety of fora for years. And so I'm particularly excited for today's seminar. I thank you all for being here. And Grant, with that, I will turn the podium over to you, and I will click off so as not to become a distraction. Thank you, everybody, for being here.
Great. Thanks so much, Jerry. And hello to all of you. Really appreciate the opportunity to talk with you today about our experiences with class actions on my side of the Atlantic here in the United States, and on Marc's side in the UK. First off, let me take just a moment to say thank you all for joining us, and to apologize for those of you who were planning to participate in last week's discussion. I unfortunately had a family member who had a temporary health issue arise. Everyone is fine now, but it required us to reschedule. So I appreciate all of you rejoining us for today's discussion, and apologies for any inconvenience that caused the rest of you. As Jerry mentioned, I'm a partner of his at Munger, and Olson in Los Angeles, California. I practice in the area of complex commercial litigation with a particular focus on data privacy, antitrust and competition issues, and environmental litigation. Marc, would you like to take a moment to introduce yourself?
Yeah, thanks, Grant. I'm a partner at Stewarts in London. I'm a commercial litigator, but mainly I say sort of financial litigation, securities, complex instruments, negligence in that area, that kind of thing. And part of the practice, a significant part of the practice, looks at large group or collective actions. So it's very much at the forefront and very interested in this developing area in the UK. Great.
Well, Marc and I thought it would be interesting to have a discussion about the experiences that the United States and the UK have had with class actions, including our histories, where we're at today. What are some of the major issues that our class action systems have had to confront? Those are going to be some of the key topics that we'll be addressing during our discussion today. And I should say up front that our comments are really aimed at those who are somewhat new to the United States and UK class action systems, who are interested in learning more about those systems, either because they may need to provide their clients with some advice on how those systems may work, or what risks or opportunities they present, but also because we thought there are some recurring issues that arise in class action systems that any class action system may have to deal with. And so we thought that this could be a discussion that potentially could be useful for those of you who are in jurisdictions that are in the early stages of experimenting with or thinking about adopting class action systems. Marc, anything else you'd like to add before we sort of jump into our topics for today?
No, then I think we'll probably get more specific as we go on. We'll start at the highest level, and then probably drill down into a few more sort of specific examples from US and UK. But perhaps if I just kick off with the first of the I suppose broad issues we were going to look at, on the sort of purposes and risks, and why countries are adopting class actions. Because that is an important background to this talk, and what made it such an interesting one to do is there has been a huge growth internationally in the number of states that have either adopted or are in the process of adopting some form of class action regime. And I think at the outset, just on that terminology, Grant, we probably just want to be clear what we mean. I think when we're talking about class action on this webinar, we mean that classic US opt-out class action, which is you get one person, they go along to court and say, please allow me to represent a whole class of people. And the court may or may not do that. That's the most simple way of putting it. And beyond that, there are other types of collective actions which may involve people opting in and ways in which the courts can organise large numbers of claimants. And I will describe them separately from class actions. But I suppose it's, from our perspective, it's this growth in the opt-out US style class action internationally that's of real interest here. So if you look at the advantages and disadvantages of I'm going to just pick two broad ones really. The advantages, the idealistic one is of course access to justice. That there are, it's expensive going to court. I'd say there's an increasing number of types of claims out there, and I think then sort of this growth of sort of data breach claims are a good example, where the values of the claim make it very difficult for an individual to take them to court, but nevertheless there are claims which people ought to be able to vindicate. Unless you pull them all together, it's very difficult to do that. And so at the most basic level, it's a way of giving people access to the court system to vindicate rights that otherwise they simply wouldn't be able to, pretty much for economic reasons. A connected reason though is if you pull all of these cases together and deal with them in one go, you're freeing up court time. Rather than dealing with dozens and dozens of separate actions in multiple courts around the country, you can deal with them all in one go. So it ought to be more efficient in that sense as well. The second broader point I'd say is more the commercial one, which has been increased, I'm going to call it marketization of litigation court services worldwide, and there's competition for that work, and the ability to bring these types of class actions, which can be very valuable, very remunerative for lawyers and others, can be a distinct advantage for a particular jurisdiction, and it can be a reason why parties will choose to bring their action in one place rather than another. And depending on what side of the fence you're on, you would want a class action because it will give your jurisdiction an advantage and make it more marketable internationally. And a lot of these types of claims that we're talking about, they're cross borders. They will involve lawyers working across multiple jurisdictions together and deciding where to start these actions. So the availability of class action procedures is really of increasing importance now in the litigation area.
That's interesting. I would say that the first advantage you mentioned, the efficiencies that you can sometimes get through class actions, the ability to aggregate claims that have small values is certainly an interest that is frequently discussed here in the United States. It also, to some extent, drives the rules that we have for class actions and how we determine whether class action treatment is the best way to go when allegedly wrongful conduct affects a large number of individuals. Given our experience that we've had with class actions, and we'll talk more about sort of our history in a moment, but there certainly have been a number of criticisms or concerns that have arisen with class action practice here in the United States. I don't mean to suggest that any of these concerns or criticisms necessarily lead to the conclusion that we should get rid of our class action system entirely, but it has led to calls for greater regulation or restrictions or limitations on class actions. The concerns, you can sort of break them down by the perspective of the different parties who are involved in litigation. For the unnamed plaintiffs, or those whose interests are supposed to be represented in the class action, the concerns tend to be whether their interest will be adequately represented by those who are purporting to represent their interests. To some extent, they give up control over their ability to litigate their own case in court. And so they have reason to be concerned and to keep a close eye on whether those who are purporting to represent their interests are in fact doing so and are doing so adequately. For defendants, there are a number of concerns as well. One, of course, is that a number of types of claims, particularly those involving small value damages, become easier for plaintiffs to litigate on a class-wide basis because it can simply be inefficient to individually litigate claims that are worth cents or mere dollars. So allowing consumers or employees to aggregate small claims can lead to more claims being brought and potentially very large damage awards. The risk of those very large damage awards, combined with the cost of defending against class action litigation, which in the United States we generally are not able to recover as defendants, even if the defendant ends up winning the case. And the risk of adverse publicity from class action litigation oftentimes combine to really force defendants into a situation where they feel like they need to settle cases, even if they find the merits of the case to be very weak. We call these nuisance value settlements. And there's been a fair amount of concern about class actions driving those types of settlements here in the United States. From the perspective of policymakers and courts and judges, I think there's a separate set of concerns. One is, are the funds that are being paid in class action settlements, or in rare cases when class actions go to trial and class action judgments, are those actually making their way to class members? Or instead, are those largely being paid out to the class action plaintiffs' attorneys? And so I think there's been a move to try and rein in certain types of settlements that result in very little recovery for class action plaintiffs and very high fees for class action plaintiffs' attorneys. Another concern that policymakers sometimes voice is that there may be financial incentives in some cases for plaintiffs' class action attorneys and the defendant to arrive at a settlement that results in a high fee award for the plaintiffs, but a very low recovery for members of the class. And so concerns have arisen about that type of arrangement and the role that courts should play in policing the reasonableness of class action settlements. Let's talk, Marc, a little bit about how we got to where we're at in our respective countries. In the United States, our modern class action system really arises from a rule that our courts adopted in the mid-1960s. But we had been experimenting in the United States with class actions for the better part of the 20th century. And our experiences may provide some lessons on how class action system design can influence the prevalence of class actions in countries that choose to adopt these systems. So if you go back to the early 1900s, we experimented with an approach where once a class was certified, basically everyone who was within the definition of that class automatically became members, with no real opportunity to opt out and no real protections for those absent class members, meaning the members who are not actually in court but whose interests are being represented. And a concern arose in the early part of the 20th century here in the United States that just didn't provide enough due process and procedural protections for those absent class members. So in the 1930s, the pendulum sort of swung to the opposite extreme, and we adopted a new class action rule that basically provided for voluntary opt-in class actions. So a class would be certified, but the only members of that class would be individuals who affirmatively chose to join in the class action. And it probably wouldn't be much of a surprise, but that did not lead to class actions being very prevalent, because I think you tended to see low participation rates. There were also concerns about that rule from the 1930s really not providing much guidance to the courts on how class actions should be conducted. So fast forward to the 1960s, and we tried what in essence is our current approach. And this is where we really started to see class actions take off. And under our current approach, it's sort of a middle ground between the two extremes we had previously tried. That middle ground is that a court will decide whether to certify a case as a class action. And when I say certify, that just means the court is deciding whether to approve it, the case proceeding as a class action. And then once that decision is made, the absent class members have the opportunity to opt out of the class action litigation. But if they don't take any action, they will remain in the class and they will be bound by the result, whether it's favorable or not. And on top of that, our rule from the 1960s provided for some additional procedural protections for the absent class members that I can talk more about in a bit. But that in essence is the approach that we have today and that we've had for the last 55 years or so. Now, class actions did not immediately take off in the 1960s after that new rule was adopted. It took a couple of decades before we really saw a ramp up in the 1980s in class action practice. And it's not entirely clear from the empirical evidence whether that ramp up is the result of the new rule structure in the 1960s or some other changes that were taking place in the American litigation system around that time. For example, we were loosening our restrictions on plaintiffs' lawyers being able to solicit clients and class representatives. Our courts were becoming more accepting of contingency fee arrangements where plaintiffs' lawyers would receive a percentage of the damage award or the settlement that was recovered. And those obviously created significant incentives for more class actions to be brought. And so it may have been a combination of those factors plus our 1960s rule that gradually saw us see this uptick in class action practice. Marc, does any of that history resonate with what you've experienced or are living through now in the UK?
We're a good 40 to 50 years behind you. We're just starting. So we've only had these opt-out class actions for 5 years. So we're really at the beginning of this. And as we'll touch on later, we've not yet had a single certified class action in those 5 years. What we have got at the moment is a range of different collective actions that have grown up over time and are culminating in the sort of US style class action proper. The background to that is, I would say, is largely to do with the financing litigation, which pushes towards being able to aggregate claims. And just stepping back, here's a sort of economic push why we end up with class actions. And I was quite surprised to find this out as recently as 1979. About 80% of the people in the UK were covered by what was called legal aid. So in other words, the state was effectively funding private litigation, cases that met certain thresholds and that, but for the vast majority of people that was available. There's been a whittling down of that and replacing it with private funding, either your own money or law firms that are allowed to do contingent fees or third-party funders who provide that. And the net effect of that is it gets more expensive. People expect a return on the money. And the ultimate sort of mechanism for doing that is to be able to pull together as many claims as you can. And that's provided a natural push to try and get to the class action point. That's also combined with, in the competition sphere coming out of the EU, that I'd say the biggest historic push towards getting a proper class action regime came on that side. The EU Commission, found over a period of time that it was regularly finding, say, cartels, but it was not seeing. So it was finding liability for cartels existing, but it was not seeing private actions being taken to get compensation as a result of the losses caused by those cartels. So what has happened is there's been a push from the EU to get member states to adopt procedures that will make it easier for the people that are affected by anti-competitive behaviour to recoup their losses. Now, the position at the moment, we only have those up to opt-out class actions in that competition sphere. Outside of that, we have broadly two other regimes that have grown up over time. One is we have group litigation orders. It's not an opt-out class action. It's not really a class action at all. It's just a more sophisticated form of managing claims with large numbers of claimants who have chosen to participate in those proceedings. And then we have a sort of a hybrid, which has not been used very much at all until recently, which is a representative action where somebody's allowed to go to court and start proceedings on behalf of a class of people. There's no certification procedure. You can just start it. The court can review it afterwards and stop you being the class representative, but the initial hurdle, you can just go to court, file your claim form, and start on behalf of a class. That's come to the fore very much at the moment because we've got two cases. One just went to the Supreme Court a couple of weeks ago. One is going to go to the Supreme Court. One is dealing with class actions in the competition context. One is dealing with classes in the representative action context, and it's looking at all the big questions that, or rather, those two cases won't look at all of them, but we're at a point where we're really starting to grapple with all of those big questions that the US process has been grappling with over the last 40 to 50 years, and we don't have answers to them really at all at the moment. So that's for the audience, a sort of precursor to what's going to follow. Is Grant's probably going to have more answers, and I'm going to have more questions in what follows. But that's essentially where we are at the moment. We're waiting on two very important decisions coming out. So when we move on to class action types, what types of cases tend to be brought as class actions? It's a tricky one because we don't have that many cases, only competition ones that have so far been brought. And as I said, none of them have yet been certified. But if we want to broaden it out and look at the types of collective actions that have been brought as group litigation orders, then what you tend to see cases in not just the competition sphere, but mass product defects, so personal injury cases, you've had those, pensions cases, and a fair amount on the back of the financial crisis, securities litigation, financial cases that just naturally lent themselves where you have multiple consumer or business claimants who choose to join into these collective proceedings, and in those it's not been too difficult to put them together and identify common issues because you're not certifying a class. You don't have that same difficulty of saying everybody has that similarity. It's just the case that they have one or more issues in common that can be conveniently managed and dealt with as one rather than individually litigated per claimant. In terms of what types of cases are not susceptible to class action treatment, again, the rather facetious answer on my part is at the moment there aren't any that are susceptible to class action treatment because the courts haven't seen fit to certify any, but I'm sure that that's going to change. And certainly on the representative side, with I know we said we weren't going to talk about case names, but there's a Lloyd and Google case, which is I think a very positive development. That's a data breach claim. And I think that there's going to be a real growth in those types of claims. I think they do lend themselves to this type of treatment. The cases that are not susceptible, I mean, I wouldn't really rule any out particularly because they're all going to be taking on their specific issues.
Great. Well, Marc, your comment about the history of the development of class actions in the UK, and in particular the influence that declining support for legal aid has had on the potential growth of class actions is really an interesting one, something that had not occurred to me previously, but here in the United States, we also had a decline in federal support for legal aid programs in the 1980s and 1990s, just as we were seeing class actions take off. So I wonder if, and I don't have any empirical evidence to support this, but I do wonder if that may have been a partial contributing factor to us seeing more class actions here in the United States. The other thing that resonated with me from the UK experience, I think you call them group litigation orders. We have a similar concept here in the United States. That is, they're not class actions, but they bring together large numbers of individual cases that have been brought in a single proceeding. Sometimes it's done through what we call our multi-district litigation or MDL process, where cases from across the country can be coordinated for purposes of the early stages of the case, like the discovery process and so forth. And then they get sent back out to their original courts when it comes time for trial. So we have a similar concept here in the United States. In terms of the types of cases that we've seen brought as class actions, look, there's no hard and fast rule here in the United States about this category of cases being okay and this category of cases being impermissible. But there certainly are cases that tend to more often appear as class actions. If you look at our overall class action cases that get filed, the leading type of case consistently has been securities class actions, meaning class actions brought on behalf of investors in public companies. That tends to be our most common type of class action here. In addition, we oftentimes see class actions brought on behalf of employees against their employers, alleging violations of various labor and wage and hour type laws. We also see a fair number of antitrust and competition claims along the lines of what you mentioned. We have consumer class actions that can involve any variety of types of claims, such as the data privacy and security claims that you mentioned earlier. We've certainly seen our share of those here in the United States. And then we have another category of class actions that sort of falls in a different bucket because it involves a different set of rules, but I think it's worth mentioning. And those are class actions that are brought on behalf of civil rights plaintiffs. So these are groups of individuals that are alleging that some conduct by government officials is unlawful or unconstitutional. And typically they're seeking an injunction to prevent that type of conduct from continuing on an ongoing basis. And so we have a different set of procedural requirements for those types of class actions than apply to class actions for money damages. So we won't go too deep into those, but I just wanted to note that that's another category of class actions that we frequently see here in the United States. In terms of cases that are not really susceptible to class action treatment, again, there's no hard and fast rules, but I think one area where courts and the drafters of our rules have expressed a fair amount of skepticism is in the area of mass torts, mass accident type cases, where there oftentimes are a lot of issues involving or requiring individualized evidence. And when I say individualized evidence, I mean evidence that will differ from individual to individual within the class. And this really, flows nicely, I think, into our fourth topic about how common the interests of the class members need to be in order for a court to find that it's appropriate to proceed with the case on a class basis. And also, what do you do if there's some sort of mixture of individualized issues and common issues for the class? And these questions oftentimes are really the heart of the debate when defendants are opposing a class action being certified. So it's hard to overstate how important these issues turn out to be in US class action litigation. And the concern obviously is if the issues are not common, if it requires a lot of individualized evidence, then all those efficiencies and advantages that Marc was talking about earlier, they really start to fade away. and disappear, because there becomes a need to have individual plaintiffs appear to testify at trial, or for other witnesses to testify to the experiences of each individual plaintiff. So the class action device just becomes unfunctional, unmanageable in those types of cases. On the other hand, the plaintiffs' class action lawyers will point out that rarely are any two individuals' claims or experiences exactly the same, and so you can't set the bar too high. There needs to be some flexibility to accommodate differences that really won't affect the manageability or the efficiency of trying a case as a class action. So the United States, we've had three requirements that really go to these issues. One is called the Commonality Requirement. As the name suggests, it requires that the class members have suffered a common injury resulting from a common course of conduct, and that they have a common legal theory. And typically, class actions that are filed can meet this requirement. It's not a terribly high bar in most cases. And the far more challenging question for courts tends to be whether the common issues predominate over the individualized issues. And that's our second requirement in the United States. We call it the Predominance Requirement. And when courts look at whether common issues predominate over individualized issues, they're not doing a mathematical comparison of the number of common questions versus the number of individualized questions. Rather, they're doing more of sort of a qualitative assessment of, is this case going to require a lot of individualized evidence, and will that tend to make the class action unmanageable? I'll give a hypothetical here to sort of walk through how I think most courts would look at these issues. Imagine that you have a train that's traveling through a city, and on the outskirts of the city, the train derails, and it happens to be carrying tanker cars filled with some toxic chemicals. Those toxic chemicals spill into some groundwater in nearby neighborhoods, and also create a cloud that starts to float over the city and dissipates as it moves outward across the city. Now, for a court trying to decide whether someone in the city who seeks to represent all residents of the city on a class basis, trying to decide whether to certify that case as a class action, they might start by looking at the question of what caused the train to derail. Was the engineer negligent, or was the railroad negligent in some respect in causing the train to derail? And the court might think that that is a common issue in a lot of cases. But as we start to move out from there, as we start to think about, well, whose groundwater was affected, or who in the city was exposed to the toxic chemical cloud, it starts to raise more individualized questions. Someone whose house is right next to the railroad tracks may have had a very different experience than someone who lived on the opposite side of the city. And so the court, to resolve who was injured as a result of the railroad accident, may have to take large amounts of individualized evidence, testimony from the plaintiffs, testimony from expert witnesses, testimony from doctors who can analyze whether someone suffered a health injury as a result of exposure. And all of those individualized questions, I suspect, would lead most courts here in the United States to the conclusion that this type of case is not appropriate for class action treatment. Although, as I said earlier, there's no hard and fast statutory rules that would necessarily prohibit a court from reaching another result, although there certainly would be strong arguments from the defendants that class action treatment would not be appropriate in that type of case. I'll just briefly mention we have one other inquiry, or one other requirement here in the United States, that goes to this issue of common and individualized issues, and that is the question of whether class actions are the superior way to fairly and efficiently resolve the litigation that can arise from a course of conduct that affects a large number of individuals. And so there, the courts tend to be comparing the class action device to the alternative of allowing individuals to bring their own claims and control their own litigation, and deciding whether class actions are really the superior way to approach the issue at hand. Marc, is this an issue that UK courts have grappled with yet, or are we sort of awaiting the word from them on how it will be addressed?
Are grappling with. I mean, this is the core of the points we're talking about. This really is the heart of it. This is where the real fights and the actual the real sort of battlegrounds are. I think, like the States, we don't have that the weighing up. It's not that we have scales and you have to have more common issues on one side than individual issues. And certainly the phrase on the competition side is sufficient commonality. But obviously that's going to be a very flexible test. And the difficulty over here for me to say, what are the tests for these sort of common and individual issues, and what's the balance, is because we have these different regimes, if you like. So I mean, I don't want to get into detail too much, but just to give you an idea, with the group litigation orders I mentioned, it talks about common or related issues. For representative actions, it has to be the same interest, and for the true class action case, it has to be the same, similar, or related issues. And there are different views in each of those. Interestingly, on the representative side, which is the one that was in the Court of Appeal recently, I mean, that really threw up fundamental differences, even amongst the judiciary, as to how one ought to look at this. The same interest has been viewed very, very narrowly, and to the point where there really wasn't even scope, as there would be in an opt-out class action, to say, well, we've got common issues on liability, but we can assess quantum on an individual basis. That would not be a bar to a class action. Representative action, you have to have exactly the same interest. And so if you have to have different assessments of damages, that could be fatal. You would not have the same interest. It was one of the bases on which the judge at first instance got rid of this Lloyd and Google case. But I was just looking at it earlier, and I think I just want to throw it out there to sort of show the real differences to how these types of claims, of how class actions, I'm sure it'll be the same in other jurisdictions, how they are seen as these new procedures. The trial judge didn't think this was a convenient case management tool. He thought it was borderline officious litigation. He noted that nobody's really complained about this at all in all the years since it happened. And he thought that it wasn't right that this representative be permitted to consume substantial resources in the pursuit of litigation on behalf of others who had little to gain from it, had not authorised the pursuit of it, hadn't indicated any concern about the matters to be litigated. And he also didn't like the fact that it was private, sort of funded by a third-party funder. That got to the Court of Appeal, and it couldn't have been a different approach. The court said, no, this is really the only way these people can pursue these claims. And significantly said, and this isn't an exception to the rule, this is an application of the rule, which is really astonishing, to sort of cement this as not even an unusual use of this procedure, but saying this is exactly what this procedure is for. And they, it's going to the Supreme Court, but it was a very, very different judgment, and it just underlies I suppose the diametrically opposed responses you can get from different judges when you have these new procedures coming through and they're asked to consider, well, have we got sufficient common issues, and how do we characterize these, and what's the test? So we're very much still in the process of finding our feet over here in a way that I think you're much more advanced in the States. I mean, just to give another example, the case that's been heard recently in the Supreme Court on the competition side, on the class certification, it failed in the Competition Appeal Tribunal because the court there said, well, we can quite see you've got lots of common issues, but you put evidence in to establish what the aggregate damages are, but we just don't think it really gets across the threshold to establish sufficiently. So we're not going to certify on that basis. which is pretty extraordinary that you have to satisfy the court to a certain level of what the aggregate damages might be before you can even get certification. That's one of the issues that's going to be looked at. So it's very, much easier. The one I've not touched on is the group litigation. That's far more pragmatic because it's opt-in. You don't have to be there. You could have just one common issue. It would still be worth running it, as a common issue rather than litigating all separately. And then you can deal with the other individual issues quite separately, not a problem. But when you're certifying the class or you're allowing a representative to go ahead and represent that class, then you get the US type issues that you've grappled with. And we are really getting very different views. Literally, first instance X, Court of Appeal Y, Supreme Court X, Y, who knows? But that's where we are.
That's very interesting. The comments that you described from the lower court, the views of the appellate court that you described in that case, very much reflects the debates that happen in U.S. Courts when it comes time to decide whether it's appropriate to certify a case as a class action or when cases go up on appeal. I think really resonates for me that there are common concepts here that impact class action jurisdictions in the United States and the UK, and we may use slightly different terminology to describe some of these concepts, but the concepts fundamentally are the same. The disagreements, the debates fundamentally seem to be identical.
Yeah, we've got are these proceedings an appropriate means for fairly disposing of the claims? Are the costs, does the cost benefit work out? Look at the size and nature of the class. Is it appropriate in that sense? Are the claims appropriate for an aggregate award of damages? All those broad overarching issues. And yet, as I've just shown, you can get completely the opposite view on these in any one case. So it's still very, very difficult and uncertain times.
Very good. Well, shall we cover our fifth topic, which is about who are these class representatives and class counsel?
Yeah, I think there's a big difference here with the sort of so on the competition side and the class action proper. I think there's a big difference when we talked about this. In that over here, the class representative does not have to be a member of the class, and I think you said over in the States they absolutely have to be. So that's an immediate distinction. Over here, there's more, the emphasis really is on whoever's going to be the class representative being sufficiently almost qualified. They don't need to be a lawyer, but they need to have the ability to give proper instructions. They need to be able to keep the lawyers under control. They need to have the financial resources to fund it, not personally, but to have put those resources together to fund the action. And they mustn't have a material interest that conflicts. That ought to go without saying. But it has to be there because I guess if the person had to be a class member, they inevitably would share the interest. But because they don't have to be, there has to be a protection to make sure they don't have any conflicting interests on that. And those requirements, they sort of feed over into the selection of the class counsel. That the class representative is going to have to show that the lawyers that are instructing have the experience, have the resources to deal with the type of action. And that's obviously not going to have to involve putting out a CV saying I've done 20 class actions before, because there haven't been 20 class actions. But you're going to expect to see firms who have dealt with group litigation orders, other types of collective actions with multiple claimants who've demonstrated that they can manage those highly complex, both logistically, legally, evidentially, very well. And one can quite imagine we're going to see at some point in the future as well issues that arise, say in the US, where there will be, I guess, competitions between counsel as to who's effectively going to become sort of colloquial lead plaintiff. There's and there's a possibility as well over here that, just to throw this as well, is that one could at the same time, in relation to a particular claim, one could have an opt-in class action and an opt-out class action, both separately represented. Again, early days, but the rules there, at least, we're not as reliant on, if you like, here, I suppose not judge-made law, but clarification there, because these requirements are at least reasonably clearly set out in the rules that already exist for the class actions. The flip side is, for representative actions, no particular guidance there. And on with the group litigation orders, you can end up with one law firm being given lead status, but equally in other cases, one that my firm dealt with, there were 3 lead counsel, and the areas of work were divided up between them by the court. They each had responsibility. One might have dealt with particular experts, the other might have dealt with particular witnesses, and it was all sort of sliced up by the courts to who would do what. So there was not one single lead plaintiff, and that meant that all the claimants who'd opted in to be involved had legal representatives who were actively involved in the process, rather than some being put on the sidelines, which I guess is what can potentially happen in the States.
Well, that's interesting. This does seem like an area where, to some extent, we've gone down a common path, but we have diverged, I think, in our approaches in one respect. The common path is that we, like you, require that the class representatives and the class plaintiff lawyers be adequate representatives of the class's interest. And like courts in the UK, we tend to look at factors like, is there a conflict of interest? Is class counsel or proposed class counsel well qualified to litigate this type of case based on their prior experiences with class actions or their prior experiences with the subject matter? And are they willing to put the resources into the case that will be required to effectively advocate on the class's behalf? Those are all certainly concerns that courts look at here in the United States when more than one plaintiff's firm seeks to represent the class. For the class representatives, meaning those in the United States, those members of the class who seek to be the named members of the named plaintiffs in the litigation, we look at factors like, do they understand their role in the litigation? Have they developed a basic understanding of the facts? Are they going to be sufficiently enthusiastic about representing the interests of the class? And I imagine similar requirements come into play in the UK, but where we really diverge, and you alluded to this, is in the United States, we have a strict requirement that the named class representatives actually be members of the class that they seek to represent. And we have a requirement here called typicality, which basically asks, are the claims that the class representatives have typical of the claims of the class members? And I think the justification for this requirement is generally that if you're someone who shares an interest with the class, who has experienced the same wrong and has an interest in obtaining the same recovery, all else being equal, you're more likely to vigorously advocate and represent their interest and to adequately oversee the work of the class's counsel. Now, commentators in the United States have raised questions about this requirement and whether it really makes a whole lot of sense. That there are certainly examples in other contexts where individuals who are not part of a group can be effective advocates on behalf of a group, and of course that's the situation typically with class counsel. So the role of class representatives in the United States litigation has also been questioned, I think, by commentators. I think there's a commonly held view that it's really class counsel that tend to drive the litigation and not so much class representatives that do so. And so the role of class representatives has certainly been questioned. I don't see any imminent change in the United States away from that requirement, but it's an open issue for discussion and debate. Now you might ask, why would someone want to be the class representative? What's their incentive? And in the United States, we have something called incentive awards, which basically results in an extra payment to those who take the time and invest the resources in overseeing class counsel and in participating in discovery. Those awards, though, tend to be fairly modest. At most, they tend to be in the $10,000 to $15,000 range. And I think courts in the United States have had some concern about ratcheting up those awards too much, because it may create an incentive for the class representatives to want to settle the case quickly, and then that might create the potential that they would settle the case too quickly at the expense of obtaining better relief for the class that they represent. For class counsel, their compensation, most of our class action cases tend to result in settlements, and the class counsel are entitled to some portion of that settlement fund, typically as fees. Exactly how to calculate those fees varies somewhat from court to court. We have two basic approaches. One is to calculate fees as a percentage of the overall settlement fund's value. And if courts go for that approach, they tend to award class counsel roughly 20 to 30% of the settlement fund in class fees. Another approach is called the lodestar method, but it basically just means that there's an hourly rate that's chosen based on competitive market rates, and then that's applied to the number of hours that class counsel spent on the case. And there's some flexibility that allows courts to adjust up or downward the class counsel's fees based on the results that they obtained or the skills that they demonstrated in representing the class. And sometimes courts will use both methods. They'll use one as their primary method, but they'll cross-check the reasonableness of the fee that they generate by looking at what the other method would show. But that's the basic approach we have here to compensating class counsel. And how about in the UK, Marc? Where do you all come out on that?
Very different, very different. Just one quick point there, so just to clarify something, and just to again throw the difficulties and differences here and how it contrasts with you. You know, I said that on the sort of competition class action side, the class rep doesn't have to be a member of the class, and that's right. And in fact, could even be a special purpose vehicle set up particularly for that purpose. At the other extreme, with the representative actions I mentioned, then the representative does have to be a member, because everybody's interests have to be the same as that representative's. So it couldn't be more different in those two regimes. On the funding side, again, quite different. Although we can do American style sort of damages based, you know, contingent agreements where the lawyers take a slice of the damages, in the opt-out class actions over here, we're not allowed to do that. We can do it for an opt-in. So if we've got a group litigation order or one of the opt-in class actions, it's fine. Things can be organised in that way, because people are joining, they're choosing to be in those proceedings. They're signing up to whatever the fee arrangements are. On the opt-out, it's very different. But I suppose the most significant point is that these actions will tend to be backed by a commercial funder, and the money that the funder puts at stake can be recovered as part of the legal expenses. but there are certain conditions attached to that. It has to be that that the class rep is obliged to pay that fee to the funders, and equally, if the class rep is not awarded sufficient to pay that fee, then the agreement provides for that lower amount. The second point is that to the extent that damages awarded are not claimed by the class members, the balance left over can be paid to the class rep to cover legal fees. So there are two ways. We don't have the loser pay. You don't have the loser pays principle that we do. So legal costs will be recouped there, and then equally to the extent they're not recouped, there's a possibility from unclaimed damages to recoup them from there as well. So no possibility of taking it out of the damages straight away in priority to the class itself. So very, very different arrangement to over in the States.
And that difference could really have, I mean, I think it's hard to understate the impact or overstate the impact that could have on the prevalence of class actions in the United States and the UK. I think the threat of fee shifting in the UK, meaning the loser pays, that threat we don't have here in the United States. And so that removes a significant disincentive that plaintiffs, class representatives and plaintiffs' class action lawyers might have to filing a class action here in the United States. And I think it really shifts the incentives in a way that encourages class actions to grow and expand. So it'll be interesting to see, I think, in the UK in the coming years, once you have more clarity on the rules of class action, but you haven't changed your rules about fee shifting, and presumably that's going to remain the same way, whether you see the same type of growth in class action practice that we had in the United States following our rule change in the 1960s. It'll be an interesting sort of empirical experiment to compare the two countries' experiences with changes in the prevalence of class actions. Well, let's see, I think we have one other topic we were going to cover today, and that is, it's like I'm having trouble getting the presentation to move forward, but that is what obligations and protections we have for absent class members, meaning those whose interests are being represented in the litigation. And in the United States, the obligations for the absent class members are that they really have to make that decision early on in the litigation about whether they want to opt out or remain in the class. And if they don't opt out, then they will be bound by the result, whether it's favorable or not to their case. In terms of protections for the absent class members, we've talked about some of them. There's the requirement of the class representatives and the class counsel being adequate. There's obviously this opportunity to opt out if they don't care for those who are purporting to represent their interests. But on top of that, the United States requires that notice be given to the absent class members at various stages in the litigation. So, for example, when the case is initially certified, class members receive notice of the certification so that they can make that opt-out decision. When the case is settled or when attorney's fees are requested by class counsel, the class members are also given notice of those events in the litigation so that they have an opportunity to come in and object in court to the amount of the attorney's fees or the amount of the settlement award. And objector practice in the United States courts is now not unusual. It's fairly common to see members of the class come in and lodge some sort of objection to the settlement agreement or the attorney's fees request by class counsel. Have you all gotten to that stage of sort of working out these issues in the UK, or is that down the road?
No, we're overly protective. We're so protective that we protect the absent class members by simply not certifying the class. So that they don't get pulled in the first place. But there's a variety of factors. I mean, we touched on the adverse cost. That itself, the fact of sort of stymieing the sort of class action culture, which the adverse cost will do, gives a very, it changes the economics of class actions. They're not going to proliferate in the same way that they do in the States. That in and of itself is a form of protection. You know, the opt-out requirement, you only become a class member automatically if you're domiciled here. So the protections by you have to opt in if you're domiciled elsewhere. So you can't just be dragged in if you're not domiciled in the UK. I touched on we can't have contingent agreements in the actual official opt-out class actions. That again is a form of protection, that the damages awarded are not going to be, large amounts aren't going to be taken immediately by those running the action as they are in the States. You know, not being procedures, we've got a very strict certification process, which is, you know, embryonic. It's finding its feet. It's controversial. Lots of questions that, you know, that we've touched on that still need to be answered. And of course, there's still the ability to opt out, and court approvals required for the settlements. So there's exactly the same types of procedures you have in the States.
Great. Well, we have already reached the end of our hour. I think maybe we want to give folks the opportunity to ask a couple of questions. May have to go a little bit past our hour deadline if that's okay with those who are operating the webinar. Feel free to write your questions down in the questions area of the webinar sort of dashboard that's should have popped up when you logged in. There's an area called questions, and feel free to type any questions that are there. Marc, I may throw this one out to you because it uses some terminology that I may not be familiar with, and I'm worried I may misinterpret. But the first question is, do people forum shop to US because of cost to book build there, whereas in UK there is a large upfront cost for book building? Do you have any thoughts on that?
I'm not sure about the book building cost side. Certainly, I mean, we have dealt with US opt-outs, and there's certainly a consideration of what the damages might be at the end of the day. I mean, you'll appreciate that, you know, there are possibilities that someone who remains in the class may get less than if they choose to opt out and take their own proceedings, either in the States or in some other jurisdiction, and potentially in some other jurisdiction as part of some collective action that's being taken in London or in the Netherlands, Germany, wherever. So I think that's one of the really interesting aspects of this growth of class actions, because, as I say, many of the claims that can be dealt with in these procedures often have multi-jurisdictional elements, and it's a really big strategic issue for clients, particularly some of the big securities actions and some competition cases and other types of financial claims. There's where you're going to go, and you have to weigh, you know, level of damages against burden of proof, against what's the legal test for making out a false representation claim, whatever it might be. You have to weigh all those things, and I think they'll increasingly involve counsel in multiple different jurisdictions working on either the book build or the taking it to court to get the best results for the people who are in that class, or whether it splits into two classes in different jurisdictions.
Mm-hmm. Yeah, no, I totally agree. I think this will be an interesting phenomenon in the coming years as we see more and more jurisdictions adopt class actions, is these conversations that need to occur across borders, much like the conversation we're having today, where we look for similarities and potential strategic differences in the two sets of systems. I think one thing that we've touched on in our comments today is that class action systems don't exist in a vacuum. They interact with other features of the litigation systems in each country. We talked about that in the context of fee shifting. I don't know if, you know, punitive damages, I could imagine being another area where we may see some differences that could impact the strategy of where to focus the class action litigation. We certainly have punitive damages available for certain types of really egregious conduct here in the United States, and those punitive damages can, easily be up to 2 to 3 to even 4 times the compensatory damages that are awarded to the plaintiffs in the United States. And I don't know in the UK whether punitive damages are as available or are as potentially massive as they are here in the United States.
No, they're not a feature at all. And I think so. A point that I was going to just touch on as well is we're talking about class actions, but it's not always going to be the case that a class action, even though available, is going to be the right course of action for a particular client. I think with these data breach, the retail type claims where you need to aggregate lots of smaller claims, they are obviously the right thing and they are necessary. And the developments we're seeing here, I think, are very positive. In the cases that have so far been dealt with perhaps say bigger claimants, which might lend themselves either to some form of class action or some form of opt-in collective action, you need to give much more careful thought as to where the benefits lie. And just picking up on your book building point of putting the action together, sure, it's easier to run an action if you only need one client, but you've then got you then have to manage the whole class. You've got responsibilities to the class through different funding issues. It may be that actually you prefer them to take a collective action with a smaller number of opt-in clients. Or, there's a whole range of complex issues that have got to be considered even when a class action is potentially available.
Yep. Well, let's take one more question, and then I suppose we probably better wrap it up. The question is, I read a recent article about U.S. firms competing to sign up plaintiffs for the Deepwater Horizon litigation. Why wasn't this class action opt-in? My firm actually represented one of the parties in the Deepwater Horizon litigation. I was involved in that case for a couple of years, so I can talk about that specific example, but we might also try to make some larger points about it. In the Deepwater Horizon litigation, there was a class. There, of course, was an opportunity to opt out of the class. For those who remained in the class, there was a claims settlement structure that was set up so that you could come in and not necessarily working through the court, but through an outside claims administrator. Each member of the class could submit their claim where they attempted to show their losses that were suffered. And there was a formula that was established for determining how much each class member would receive. Some class members chose to opt out of the class action on the belief that they could obtain a better result through litigating their case in courts rather than trying to work through that claims structure that was set up. And one point I would make about the Deepwater Horizon litigation that I think is more generally applicable in the United States is that sometimes defendants, although they certainly have concerns about the American class action system, there are times where defendants view class actions and class action settlements as being advantageous to the alternative. And the alternative, in some cases, can be the threat of having to face thousands or tens of thousands of individual lawsuits. Of course, those are enormously expensive to litigate in terms of the attorney's fees associated with defending each one of those cases. But each one of those cases also can pose its own threat of a very large damages award here in the United States. And so there are situations where defendants view class actions as being a preferable device because it allows them to settle a large number of claims all at once and essentially get what we refer to as total peace or near total peace that allows them as a company to move forward and move past the litigation while resolving a large number of those claims all at once. Marc, have defendants expressed any interest in the UK in sort of facilitating class action settlements as a way to avoid having to deal with large numbers of individual cases?
I don't know whether there's a group that have, but I certainly had the odd conversation where I've been quite surprised and expecting defendant. I've got to be careful saying defendant lawyers. We don't have a kind of claimant bar over here. You know, we all tend to do claimant and defence work, but you know, some of the big firms that one would typically expect to find on the defence side in class actions. Generally, I'd have expected them to be very anti class action. I think that's, I'd say, just anecdotally on conversations about still the majority view, but certainly spoken to some people who've expressed similar views to what you just outlined about some of the benefits for corporate defendants of being able actually to amalgamate, you know, all these multiple different proceedings into one set of proceedings and to try to find, you know, ways within that the class action procedure to get a better result than they might otherwise be able to do with multiple actions in different, well, not just multiple actions in one jurisdiction, but potentially having them all dealt with, you know, in one jurisdiction. Trickier to do that, but again, I can see the advantage of that for a defendant.
Great. Well, I think we've probably reached the end of our allotted time and beyond. Thank you, Marc, very much for participating with me in the conversation today, and thanks to our audience members for attending. Certainly, if you have any questions following the discussion that we didn't have a chance to answer, don't hesitate to reach out to Marc or I with those questions, and we'd be glad to talk more with you about them. Yeah,
Grant, I just wanted to say, because I'm conscious it's quite high level and deliberately so because of, you know, the UIA's members and where people might, you know, which jurisdictions they might be in, not wanting to be overly specific, but just touch on these general issues. So yeah, if there are any specific, more detailed points, then please do get in touch.
Definitely. Thank you all.